All right, thank you. Much appreciated. Oh, you big time.
Hi team, we're all good to go now. Live streaming has commenced.
Oh, excellent. Thank you.
That wasn't easy.
I appreciate that. And I knew it. Thanks, Lindley. I knew it didn't start till 11:30, but it's good to have a few things ironed out. There's Robert, Lisa, we've got Dan, we've got Jeremy, and all quite a few of the McDonald's team is also online. I'll put my video on. Sorry, forgot about that. Now, can everyone hear and see everyone else? All good? No dissenting voices? So look, obviously this resumed hearing is to just hear from McDonald's with regards to their closing or their right of reply, which was provided to us late yesterday. And Jeremy can confirm, but it included a written statement, written submissions from yourself. There was, I think, 5 different appendices. I'll just confirm that.
Correct.
Yes, and two of them are essentially the same. So attachment 1 was a revised set of conditions. It's in both PDF and Word. Thank you. Attachment 2, which is the biggest of the attachments, is an updated plan set. Attachment 3 was Mr. Parkinson's supplementary statement, which you refer to in your reply. Thank you. Attachment 4 was the fast track application plans, which are actually on the public record. Thank you, Lisa. Lisa found them for me this morning. I was looking around and I always find MFE's website a bit weird. And attachment 5 was some correspondence between LNDP and members of the McDonald's team. So that is what we've got, and I don't propose to say anything more unless Lisa and Rob, do you have anything preliminarily that you want to mention? Nope. That's
no,
great.
nothing from me. Just happy to hear the submissions. Thanks.
Thank you. So Jeremy, just the usual process will follow. We'll leave it to you to take us through the closing. I'm pretty sure I'm speaking for all of us. We've all had an opportunity to read them. Probably not in as much detail and with as much time as we would like, but I've made a few notes in a couple of areas that I will likely query you about. My plan would be to just let you take us through them, and then I'm just going to open it up to my fellow commissioners to ask you any questions of clarification, etc. My position is I didn't spot anything in the closing submissions that would raise any flags such as, they're not within scope, or such as you've raised issues that weren't raised by submitters. They're clearly, as I would have expected them to be, clearly tick all the boxes in terms of those, legal requirements. So that they aren't the things that I would be talking to you about. So I'm just going to leave it to you, take us through, and then I'll revert back and we'll see where we land with regard to any questions or comments that my colleagues wish to make.
Thank you. So you have the reply submissions you've indicated, and I will speak to those. So I understand you've only had this morning to look at them, and so if need be, we can obviously dive deeper as we go. But I won't read them out word for word. So the first thing, of course, these are reply submissions, and I've been careful to make sure that they're engaging with issues in that context. They follow our hearing on 25 to 27 November, which you will recall, and the position remains that the proposal before you is for a non-complying land use consent. There are some amendments to the proposal that I refer to in paragraph 5. Now, they're relatively discreet, but I would also say to you that they are of some importance. Firstly, there is an adjustment to the operating hours of the restaurant. Now, the opponents of the proposal have had a bit to say about 24/7 operation and its appropriateness or not in Wānaka. I will come back to that and I will make some comment on it, but in some respects, it's arguably a somewhat moot proposition now, given the adjustment in the hours. Perhaps the most significant implication of the adjustment of the hours, as you would appreciate, are the consequential implications then for lighting on the site. And so the McDonald's team have advanced some amended conditions of consent that address that aspect, and fundamentally what it obviously opens the door to are lights being turned off overnight while the site is not operating, and that has a range of implications then for concern about night sky, character, amenity, and the like. The other tweak to the proposal is the adjustment to the height of the blade sign. Now, that blade sign height is reduced to 2.2 metres, and you may or may not have picked up that height aligns with the consented height as it stands for the Caltex sign. So that is the reason for the 2.2 metres, is the heights have been aligned as between those two. And you will recall in my opening, I referred to a range of steps taken by McDonald's to walk back from its normal signage proposition for a restaurant, and this is our further step again. So in that sense, what is in front of you is a restaurant which has significantly less signage than would normally be the case for a McDonald's located in an urban environment, and that of course is an acknowledgement by McDonald's that it is appropriate there be a response to the particular characteristics and context of this site. The revised package of plans, and you'll see, sorry, just in the round brackets there, it's an amendment to the blade sign, not the blade site. So that's just a typo, sorry, at the bottom of my page 1 in paragraph 6. The package of plans is a complete one, even though the only change is to the blade sign. And that's because I've found over time, I think it tends to be much more helpful to provide a complete package. If one starts throwing in individual replacement pages, it can rapidly start getting confusing. So that attachment 2 is picking up that blade sign change. There aren't wider changes within it. But it is advanced as a package to make it easy for you to understand the final version as proposed that you should be looking at as commissioners. It brings me to some initial observations, and I've been reflecting, as one does, on the hearing and the matters raised in the context of preparing the reply. And in my opening, I spoke to the fact that the analysis of the site, its context, the somewhat unusual environment, of course that's a reference to the environment, has defined applying, particularly by reference to that consent activity for the site, likely to be given effect to are critical and distinct considerations against which the proposal is assessed. And I don't think anything has changed the relevance and correctness of that observation. The amendments that have been made do not alter my acknowledgement that the proposed activity taken in and of itself is urban in nature. And I think it's fair that I continue to accept that the pathway to consent is a narrow one, particularly by reference to the zoning of the site. But I say, as I did in my opening, that the application for consent should be granted. I say the evidence you've heard has underpinned that proposition as being the right one. And I also say that the amendments to the proposal I've just referred to strengthen the reasons why you may and should conclude that the grant of consent is appropriate. As you know, there remains disagreement between McDonald's experts and council reporting officers as at the end of the hearing. Now, you may well ask, and I imagine you will, for the opinion of council officers on those amendments that I've referred to, because they have not previously seen those, and so that is yet to come. But by reference to the position prior to those amendments, there remained disagreement around some key matters. There are a package of other areas where, in fact, there's a high degree of alignment. And so I go on to touch on some of that in paragraph 10. Largely, there is agreement that the character of the site doesn't align with its zoning, and that's reflected both in the evidence in front of you, specifically tied to this proposal, and it was something that was addressed and discussed in the context of that earlier Environment Court exercise that resulted in the Mount Iron Junction consent. The evidence in front of you, I say, illustrates that both the site and the surrounding environment have potential capacity to absorb urban development. And I say to you, that's unsurprising in the context of a fair appraisal of that surrounding environment and the fact that there is a comparatively significant degree of existing development. And really then those differences of opinion boil down to the ambit of new development, which could be accommodated in a particular location. And it's interesting in the context of all the material before you, that in many respects, the key issue is boiling down to a very discrete and quite focused consideration about where this proposal sits on the site and the importance of setback or not and the backdrop. Now, there's the somewhat vexed issue of what distinction one might make between peri-urban and semi-rural, and I did turn my mind to whether a Christmas gift to you might be a lengthy exposition on the differences between those or not. And it struck me ultimately that even assuming, I don't know that there's a holy grail of answer out there which would nail it to the floor. And ultimately, I think, the more I thought about it, it seems to me that practically the variance between those sort of propositions is nuanced, it's relatively fine, and trying to really lever the issue into one of those two boxes is perhaps not that helpful and also not that necessary ultimately. The built form and activity that's proposed here, broadly there's agreement that it's relatively benign, and there's that further statement from Mr. Denny, which acknowledges in the context of constraints of the site and so on that the building is relatively modest and relatively well executed, and that reflects, as you recall, a range of considerations, some of which on explanation, for example, from the applicant's architect, give you a real appreciation for why the proposal has been undertaken in a certain way. So you can, for example, shield surfaces on the roof and the likes. And of course, you'll recall it's about 450 square meters. It's maximum 6.1 meters high. It is fundamentally not a large building. I say to you then that it follows that it's not tenable as a general proposition to say, look, if a building of this size is placed on this site, then no matter the detail, look, just adding it in any shape or form is the straw that breaks the camel's back. That sort of generalist proposition would be an overstatement. And the point being made there then is that meaningful opposition to this proposal is founded on the finer detail of the location of the building. And that's really where this matter devolves to. Now, in paragraph 10D, I refer to adjustment of some of that finer detail, and in particular, post-hearing, a response then to the lighting issue. And I just remind you in passing as well that that protected landscape area on the parent site, which is the most significant and the only area that's formally protected of the outcomes of that earlier Mount Iron Junction consent exercise, is unaffected by this proposal. And I say as a result that careful consideration of the evidence in opposition is revealing, in the sense that the fundamental proposition, as I understand it, from Mr. Denny and Mr. Baxter, is that the building is too close to the roundabout. That in essence, that grassed area, which the McDonald's building is proposed to sit on, it is the loss of that which tips the balance for the broader site. It is a setback issue, ultimately, that we are talking about. Now, the McDonald's position, as reflected in the expert evidence which you have, is that the importance of that area of grass fronting the roundabout is overstated, that it has been given too much weight and too much importance. And that I would say that there's an anchoring in many respects to that consent order of the Environment Court. That the McDonald's position also engages with Mount Iron. And as you know, there's no argument about Mount Iron being a very impressive and important feature, and it's identified as such in the plan, as you know. But I say to you that the potential for adverse effects on Mount Iron is not borne out by a measured consideration of the size and value of that feature and the enduring power of those values. And those values endure and strike you when you visit this location, notwithstanding the existing development of urban zoning wrapping around almost all of the feature. And despite and notwithstanding the consented development approved for the site. And I say that the proposed restaurant, as amended, because I think it's a relevant and meaningful change to no longer have illumination overnight. Of course, you can't see Mount Iron at night, but the considerations are slightly different in that context around visibility and activity and the loss of that sort of darkness in the evening, leaving, of course, to one side the fact that lights are blazing on the roundabout. But I say to you that the proposed restaurant is simply not of a scale and nature which can compete with or detract from Mount Iron. And that's obviously a matter that ultimately you have to grapple with. And I would simply remind you, as I did during my opening, of course you're looking at those visuals, but if you're not popping down there for Christmas, then you'll just have to take the trip in your mind. Take yourself back as well to standing there where you can see Mount Iron. And remember, I think in one of the statements of evidence, there's a reference, may have been Mr. Denny or Mr. Baxter talking about in some areas you can potentially see it from as far as 20 kilometres away. It is a significant landform. Is it really true that when you approach that roundabout, a building of the modest size proposed here, with the landscaping proposed here, the changes that are proposed here, are going to have a material effect on your appreciation of that feature? And I say it just can't, it just doesn't, it just will not. And the expert evidence for McDonald's supporting that position, I say, is bolstered by what, in my view, are pretty balanced and real-world lay evidence from Mr. Cossins and Dr. Powell. where they expressed the same view. Somewhat tied to that scenario was this whole idea of a gateway, always fraught. It's fraught in this scenario. I've had and been involved with discussions / arguments and a range of other applications around New Zealand where gateways get talked about and whether they offer additional opportunity or whether they reflect a constraint. What I would say here is if you look at a sequence over time for Wānaka, the gateway has shifted and there's evidence to that effect. It's shifted over time as Wānaka has changed and grown. That's unsurprising given that growth of Wānaka. You've also got evidence in front of you that that's not an endless sequence of shifting deck chairs, because what is firm, and Mr. Smith spoke to this, and I think there's some agreement about this, is that the river itself is a very strong delineation, and there's no prospect, it seems to me reasonably, that you would have over time the gateway going beyond the river, because the landscape and the character and the event are clearly different beyond that. But if we step back then to the Wānaka side, the gateway, wherever it might be, there's agreement that certainly it's moved around. And beyond that, it's a somewhat nebulous concept that needs to not be overcooked. And it's also not a concept that is enshrined in any of the planning documents in front of you. So whilst I think it's fair when you're considering amenity and character to acknowledge that, you know, just as a layperson arriving, there is a sense of arrival. That's something that is of note for how you perceive a place. I don't think we're going to get too carried away with this gateway concept per se. It's perhaps better to talk about what your perceptions are when you arrive. And that reflects as well then a sequence of things you experience as you move through an environment. So that brings me then to matters arising from paragraph 11. And I refer then at paragraphs 11 and 12 to those amendments. And I've briefly spoken to those already. Paragraph 13 then is a reference to proposed lighting conditions of consent. And that's, of course, some engagement with the fact that whilst before, if there wasn't a closing time, then there wasn't a need for the same level of precision about how lighting would work. At least there isn't a scenario where lighting was being turned off and what that looked like. Now we have conditions which are adapted. They're not exactly the same, but they are adapted from that those conditions applying to the consented Caltex, which speak to external lighting, and you'll see there's an exclusion there for sensor-activated security lighting. And you'll see an exclusion for signage there as well. Just to be clear, that's not a proposition that signage would remain lit overnight. It's simply reflecting that those matters in Romans 1 through 5 that follow have some express references to things like filtering or light being intended to face downwards only. That doesn't quite fit with what how the signage works. But so there's some control there. And in paragraph 15, then I just have recorded, it probably goes without saying, but the fact that Mr. Smith is supportive of that change. I did discuss with him whether he should produce a supplementary to that effect, and it really seemed, to be honest, rather superfluous because, as you know, he's supportive of the position prior to the lighting, and this has simply improved it from his perspective, and that's why there isn't a direct additional 1 or 2 line commentary from him. If you thought it was necessary, that could be obtained, but I don't think that it is. That takes me to 24/7 operation, and there was a temptation for me, given the adjustment to the hours, to simply walk by this issue and not engage with it at all. But I think I do want to make some observation about it because it's been put on the table as a live matter. I guess to a certain degree, the hours of operation have some relevance to considerations like character and amenity. And also, frankly, it feeds into a hobby horse we're engaging with elsewhere around real-world assessment. And the point then I want to make is fundamentally that there's nothing inherently inappropriate with a 24-hour, 7-day-a-week business operation. As you would imagine, operating with those hours generates various effects, and you're familiar with those, and there's traffic, there's noise, there's lighting, there's activity. Those things have all been assessed. And perhaps with some debate previously about lighting, the other matters there was agreement on in terms of traffic and acoustic matters. But at paragraph 18, I then respond to this proposition from Mr. Barker that there's a risk to public health and safety. And frankly, that's just completely misconceived. And the first observation is that a 24/7 operation could occur in 3 parks, providing various controls, rain to noise and lighting are complied with. And as you would appreciate, the point then is that, in fact, 24-hour, 7-day-a-week operation is provided for in Wānaka already. Now, the point made in paragraph 20 then is whether it's viable or appropriate or necessary from the perspective of the operator to have hours such as that very much ties to a combination of demand for the particular service and potentially the nature of the particular service. There are gyms in Wānaka that are open 24/7. It may be only particularly enthusiastic people that are there doing dumbbell lifts at 2 a.m, but nonetheless, they're open. And if the concern is a risk to public health and safety, frankly, the risk of someone dropping an overly ambitious weight on themselves is perhaps a higher level of risk than a McDonald's operating. There are bakeries in town. Now, those don't operate 24/7, but the point being made there, as you'll see, is that you can't magic sandwiches and donuts into existence at 6 a.m. Someone has to get up early and prepare them and create them. And so I've referred there to advertising that's currently publicly available for bakers starting at 3:30 a.m. And then we have the ski fields. Now, those are seasonal, but if one wants to head up the mountain and rip it up on nicely groomed corduroy, that only occurs because there are people up there on groomers overnight. And again, there's publicly available information indicating those hours. And so it's really a simple point being made. One, it's not true to say that nothing happens in Wānaka in the small hours. And two, and perhaps more importantly, if you're talking about operation of a convenience restaurant, there's no suggestion or evidence in front of you that generates any sort of specific hazard or health or safety risk. I go on then just to mention some other issues that flow from that. There's some evidence in front of you about change in time over the health offering. And I appreciate that for Wānaka residents, there is a concern about the infrastructure they have. For better or worse, frankly, even living in New Zealand's largest city, we are not free of concern about the infrastructure we have and benefit from, whether it's up to the task. What can be said is that it changes over time, that steps are being taken, and you would have seen in footnote 7 an example of progress being made. And I'm sure locals may quibble about whether it's enough or whether it's fast enough, but it is not a scenario where the community is unresponsive to health and safety matters. And I don't think I need to take that any further. That feeds me then into paragraph 23. Again, hours, but tying to the reference by Mr. Baker to some McDonald's locations overseas and the hours that they may have, and then a direction from you, the panel, in your minute 4, asking for some commentary on that point. Now, it's primarily answered by the fact that the operating hours have changed. But what I can say, in addition, having had the McDonald's people undertake some investigation of the hours, it's true to say that in Zermatt, that restaurant doesn't operate 24/7. It's not entirely clear exactly why that is. And I would say that the appropriateness of any particularly operating hours here in a town in New Zealand cannot properly be determined or influenced by what hours there may be in a town on halfway around the world, which is subject to its own circumstances and its own planning regime. From paragraph 24, we're back, for better or worse, speaking about the environment and how you deal with it, which I'm sure is something you are looking forward to grappling with again. It is, from a legal perspective, a scenario where my submission to you has not altered by reference to matters that have been put before you about the correct way to go about it, but there are some comments that I can make in the context of things which have been advanced by others, including opponents of the proposal and council officers. So in paragraph 26, I have referred to the fact, as you know, that the most unusual aspect here, or the tricky aspect here, is that future state of the environment. It's something I referred to in my opening, and the fact that it's a somewhat unusual concept, and I should add that Mr. Herbert was concerned that I was being condescending about that issue. And I can assure the panel, and if you go back and listen to my submission, you'll see that this is so. That's not the point of the observation I made. The observation I made really is one where, as practitioners in this area, it's fair to acknowledge that it is, in some respects, a legal construct as to how you go about the exercise. And so the point being made for lay people is that can be an unusual thing to grapple with. It's not suggesting it's something they can't understand. It's just an unusual outcome of the way that the law works in this area. So you have that likelihood question, of course, and then there are some issues inevitably, even though it's not playing directly into the environment as defined, but there are inevitably some questions about the fast track approvals bill, which you may be aware passed its third reading on the 17th. As far as I know, it hasn't received the royal assent yet, so it's in the twilight zone between being a bill and an act, but it is about to burst into effect, assuming that the Governor-General gets to it before heading to the beach. So, as a preface to any additional comments I make, I would remind you that that consent order from the Environment Court wasn't the subject of a contested hearing. It's not a decision or determination on the merits, and statements by the court about its views on characteristics of the environment are not binding on you. And those observations are correct. They are legally correct. They remain legally correct. And I referenced that back because a lot of time and investment has been put into discussion about what was before the court and what people did or didn't say in the context of mediation that occurred and where that court outcome ended up. It is a relevant thing to consider, of course, but what is most relevant about it is simply the output of the exercise. The findings of the court, such as they are, do not have the same power and relevance because it simply wasn't an exercise which involved a proper contest on the facts about the state of character, amenity, and the environment. So paragraph 29, I start by talking about the receiving environment outside the site. I identify there some matters which are relevant to you, even though they're not visible right now. Before speaking to, in the context of this case, the somewhat infamous roundabout, which has taken on perhaps a somewhat exaggerated importance in some respects, if only to the degree to which there's been back and forth about what its effects are and when those were known and what consideration was given to it before. And it struck me thinking back that we became somewhat bogged down in discussion, in particular, about the extent to which the design of the roundabout was understood by the court in the context of making the consent order. And the suggestion put to you by opponents of this proposal is that a relatively detailed design might have been available to the court. And I say to you in that regard this. First, I agree, the court was aware that a roundabout was to be constructed, because after all, it was that which was to provide access to the development from the state highway. What I don't agree with is any direct proposition or intimation in a more subtle way that the court undertook some detailed consideration of what the implications of that piece of infrastructure would be for landscape character. And you'll see in paragraph 31, I go on to refer to the landscape affidavits that were before the court, which I have read, and they do not engage with the design of the roundabout and its implications for character and amenity. The affidavit of Mr. Denny doesn't mention it at all, and that of Ms. Smitham only does so in passing without any analysis of its design or effects. The planning affidavits that were before the court from Mr. White and Ms. Blight simply state that the future roundabout will change the character of the area, Mr. White's reference, or change the landscape of the vicinity of the site, which was Ms. Blight's observation, but there is no additional commentary. Accordingly, I say to you, it's unsurprising that the court's consent order makes no reference at all to the roundabout. They didn't have any evidence before them about it. There wasn't any discussion about what it meant. So there is no engagement in a detailed way with that issue. So I then say in paragraph 32 of my reply that the implication is, look, the roundabout's completed. It's one of the things, sometimes you end up talking about matters in this way when you have a retrospective consent, and one can point out that if nothing else, the upside is the thing, whatever it might be, is there, and you can actually see what effect it has. Here, the physical completion of the roundabout now enables you to undertake a proper assessment of and understanding of its impact. And in that respect, I say its final form is something unassessed and new since the consent order was made. But I don't want to over-egg that. We're not hanging our hat from a McDonald's perspective simply on the implications of that. The point being made is simply that the roundabout and its final elements, all those things you can now see, the curb and channel, the footpaths, the cycling lanes, the LED street lights, all contribute to a peri-urban character. It's a relatively recent piece of infrastructure, and it has clear and observable implications for the amenity and character of the environment. And I am simply saying to you that those implications can't just be undermined or discounted or treated as things that have already been sort of considered and settled by reference to the consent order, because that is not what the consent order did, nor can it do, because it wasn't a contested discussion around those matters. So the other consideration note outside the site that I'd simply draw your attention back to are those road corridors and something I mentioned earlier, that concept of arriving or moving through a space and what you experience as you move through. And again, that's about trying to avoid getting locked into a static visual, which in many cases is, for understandable reasons, a worst case position to consider the implication of consenting something, and that's right and proper that be chosen. As you know, the courts tend to expect that you don't just pick, your best side. You are expected to present the most challenging of the views that may be available. That's a different thing than how that particular view might be experienced, and often, particularly in the context of a corridor through which people move, it is something in the order of a split second or only a matter of seconds where that might be experienced. And the duration of an ability to appreciate that view forms part of any assessment of the scale and implication of that sort of effect. So paragraph 34 then refers to moving along Riverbank Road, and the key point being made there is this large suburban area that will eventuate out of the 3 parks scenario, and specifically you're going to move through approximately 2.5k, something of that order, of urban environment before you hit the site when that's developed up. That approach from Albert Town, you'll recall, and there's a chunk of development there that exists, but there is, and the point we made there is more to come, and you need to keep that in mind. The State Highway 84 approach is a more unusual one, isn't it? And you'll remember that. You move your way out of Wānaka, and you have, of course, Mount Iron itself on the left, and there's the car park, and it effectively comes all the way down to the road, and you're not going to have development along that section. But on the other side, you have 3 parks, and notwithstanding that there's a slight drop of elevation and there's some small areas where it's slightly set back, if you were to take your mind's eye back, or if you were to do a classic Google stalk and make your way along there using Street View, you can see that 3 parks development for a long section as you move along State Highway 84. So you've got Mount Iron to your left as you leave Wānaka, but that 3 parks is there overlapping and extending beyond for a long period of time. And the implication of that is you're conscious that you're within Wānaka as a result. You haven't left that area. That doesn't undermine the importance or the power of Mount Iron to your left and its significance and the appreciation you may have of it. It's simply that you're aware as you look to the right that you're still within that expanding area of Wānaka, and that flows through then also to Puzzling World, which by its very nature is somewhat odd looking, but it reflects an attraction that has a tie to that urban area. Now, I think the viewpoint from the south, as you come across the Cardrona River, come through on State Highway 6, that's a slightly different one, isn't it? And you've got that evidence in front of you. I'm not going to repeat it other than you have that very clear step change as you come over the river. And I suppose in a lot of ways that is one of the key considerations and determinations you're going to make. That is the direction you come from, where there is the least development as you make your way along. Due to the change in elevation, you sort of cross the river and pop up. Now, you can see Mount Iron substantially earlier than that because it is so high, about 250 metres high. You see that much earlier. But in terms of those matters lower down, you will come up and pop up and you get to the roundabout. And that's where, if the McDonald's is consented, as I say it should be, you will see it. And the question is, how significant is that if it's there? How important is that if it's there? How much does it alter your impression of and appreciation for what opens up in front of you is you climb up out of crossing the river from the bridge and pop out. Now, I would say to you, in fact, what slaps you in the face is the roundabout. Boom, you've arrived into an area where there is a whole differential in what you're moving through. You've hit the point where it's obvious with the signs and the lights and the size of the roundabout and there's the vet to your right and the other buildings starting to become visible. Things have changed now. And I say to you that the McDonald's being there doesn't have a significant implication in that context if it's a well-executed development, which we say it is. And I also say to you that large Mount Iron looming over you will retain its impressiveness and power and amenity and character, notwithstanding a McDonald's building being there, because frankly, it's 6.1 meters high, it's screened with landscaping, and it's seen in the context of that roundabout. As for the site itself, which I talked to from paragraph 38, you're familiar with the change to the site already. It's obvious to the naked eye. And then we have, of course, the implication of that likely test. And in paragraph 40, I speak to, as I've already mentioned, my submission to you that irrespective of what occurs on the site by reference to that Mount Iron Junction consent, that Mount Iron will continue to be the most dominant feature, standing 250 metres above the site. Which takes us then at 41 to the townhouses and workers' accommodation. And I think it is fair to say that that position is somewhat awkward. It's somewhat complicated by the opportunity offered by the fast-track consenting regime. And it would be simpler for all involved, including me, including for McDonald's, if you didn't need to grapple with this issue. But needs must. In law, we have to grapple with it. Paragraph 42, I repeat that submission to you so you don't lose sight of it, that resource consents are permissive. There's nothing that says that Mount Iron Junction must build those townhouses and workers' accommodation. They're not required to. It's not an obligation that they do that. You also have in front of you that clear statement in a letter from them that they're pursuing an alternative, and there's a clear inference to be drawn from that fast-track application they've made. The law imposes the likely test. I didn't make it up. The courts are the ones that have put that test in place. And I say to you that there's clarity that the townhouses and workers' accommodations currently consented are not likely to be given effect to. Now, I know that my friend representing Willow Ridge, Mr. Herbert, was troubled by this, and she talked about the fact that that part of the consent hadn't been surrendered. But that's not the legal test. And of course, the courts could have made it part of the legal test if they chose to do so, and they didn't. You have to deal with the legal test that we have and the evidence that we have. And so there's that discomfort from opponents of McDonald's about this proposition that you don't take account of the townhouses and workers' accommodation in the context of the environment as defined. But that you also don't take account of, as part of the environment as defined, what might occur or fall out of the fast-track process. And I can understand, at least the same doesn't apply to Ms. Hill because she should understand it as a lawyer, but for a layperson, this is where some of this futurity in this process seems strange, because from their point of view, they find it odd that if you discount, as it were, the presence of the townhouses and the workers' accommodation, because there's clear evidence an alternative's going to be pursued, well, how come then you don't count that alternative? And the answer is, it's what the law says, and it's also, I say to you, not an unusual scenario. You will all be familiar, I'm sure, with scenarios where consents are obtained and left to lapse, with scenarios where consents are varied, scenarios where consents are given effect to in part. That may be because the original proposal is abandoned. In other cases, it might be because an alternative is in prospect. And if an alternative is in prospect, there are scenarios where consent sought for that straight away or imminently. There's scenarios where it's a hoped for consenting exercise in the future, perhaps when the economic positions change or something else occurs. And ultimately, in either case, any new consent proposition may or may not be granted. None of this is unusual. They're difficult to grapple with in certain circumstances, but they're not unusual scenarios. And so my submission to you then is what is ultimately important, what is ultimately relevant, is not whether a particular development or part of a development is consented. That's not the singular test. The question is whether it is likely to be given effect to, because that's what the courts have said. Now, in paragraph 45, I speak to the fact that, it's likely that an application is going to be made for a fast-track consent, but that's not sufficient to bring that proposition within the environment as defined. And in paragraph 46, ultimately that evidence in front of McDonald's is, even if you did consider the townhouses and the workers' accommodation, then there is still a pathway to consent, and the McDonald's witnesses maintain that position. Now, make brief comment on the legal submissions for Willow Ridge and Jesse Herbert. And for the reasons that I've identified, I say those submissions are in error. I also reject the proposition that my legal submissions were somehow selective or legally flawed, because what I have put to you is the law as it stands. And perhaps, in a way, the best thing that could be said about this, and to underline the point, is, as I identify in paragraph 48, the actions being taken by Mount Iron Junction are the epitome of a real-world situation. This is the whole point of why and how the courts say you should engage with the issue. Mount Iron Junction have become aware of this new alternative. You can debate whether we should have this legislation. I know lots of people would prefer that we did not, but it's what we have. Mount Iron Junction become aware of that alternative, and they're exercising their right not to give effect to the entirety of the consent they've got, because they're going to seek to progress an outcome under this new legislative alternative. One imagines there are financial imperatives behind that choice. I'm sure that's the case. One only has to have a look at the plan, which we'll get to, and how much development they're proposing to see that that's presumably what's driving that choice. But as a result, it's nonsensical in my submission to try and attack the implication of that choice as being artificial, because the opposite is true. This is a real-world example of what can occur, and the McDonald's approach simply reflects the law in that respect. In paragraph 49, I indicated disagreement with my friend's summary of the findings in care. I don't think a huge amount turns on that, but the short point really is it's not correct to say that the courts took a view that underlying subdivision wasn't relevant as a factor to count towards likely implementation of a land use consent. It certainly can be relevant. And in this case in particular, it's a different scenario anyway, because we're not talking about whether or not a plan has been submitted in the context of 223. In other words, submission hasn't been completed. And what's the relevance of that? Here we have a scenario where the subdivision has occurred and we have titles issued. And that clearly has implications for the environment. From paragraph 50, I speak to visual amenity character effects. And in most respects, really the position is one that it is not for me to opine at length, because I'm not going to sit here and repeat all the evidence that's in front of you. You will have to make a finding as to whether you have views that align with those expressed by Mr. Smith, or whether you prefer the evidence in front of you from Mr. Denny and Mr. Baxter. Those amendments we've spoken about are ones that you need to bear in mind when you consider the position now. And I just would return briefly while we're talking about degrees of effect and character amenity and so on. In paragraph 52, I just return briefly to that consent order issue, and you'll recall that I've already spoken to you in this reply about having a look at the affidavits and what they may have said or not about the roundabout. The other thing that's of some interest in that regard is the affidavits express a difference of opinion between Ms. Smitham and Mr. Denny about degree of adverse effect. So we have one sitting at very low and one sitting at low moderate in the context of that application the court was considering. And Ms. Smitham considered, in addition, that the original proposal, so that's the one which had a lot more development in it, had effects of a low degree. And the point I am making really is twofold, I guess. One, that Ms. Smitham, and this is an opinion that is effectively shared by Mr. Smith, given the evidence you've got in front of you, is of the view that the site can absorb additional development over and above what the Environment Court ended up consenting. And the point it's important you understand is that the court didn't accept or reject that proposition. They didn't engage with that. And that's another reason why the consent order issued by the Environment Court is not determinative with reference to the assessment of effects with respect to landscape matters. The court, if you look at that consent order, subject to those reservations, as you know, about it not being a reasoned decision, does not plump for one view or the other, as between Ms. Smith and Mr. Denny. It doesn't express a view. It simply says where the position ended up is one it could consent. But there's no preference or analysis by the court as to which of those views is correct. And that's why you need to treat with care what the implication of that consent order is. In 54, there's just a couple of observations made by reference to some comments from Mr. Woodford, and in particular, from memory, I think he had gone for a drive either the night before or that morning before speaking to you, and there were some comments made about, and these are smaller things and smaller factors, but he had made some comments to you about, you know, what's, for example, clustered mailboxes and lack of footpaths, and what that might mean in terms of your consideration of effects and the character and amenity. And there are some observations made there that point out that these things occur in urban environments also. They're not determinative issues. In para 55, we're just recording that point that I think was made to you during the hearing, that sadly there isn't an ability to progress a private plan change for the site. But notwithstanding, the site doesn't have the same values as Mount Iron. It's adjacent to it. Mount Iron is relevant when you're considering development on this site, but the values are not the same. Now, both Mr. Smith and Mr. Denny outline the importance of protecting views to Mount Iron and the way in which it contributes to that entry experience. But the PDP doesn't require the site to remain entirely vacant of built form, and that's evident because that priority area doesn't extend to this site. And that leaves you then with that clear difference of opinion, ultimately, about setback. And is it enough? And is the loss of it significant? And of course, I think I need to make some comment about, or because reference was made to it by Mr. Denny, about Mr. Smith responding to a question from you about whether he would regard development sitting further back in the site as better, and he indicated that he would have a preference for that to the extent that he felt effects would be less if the setback was greater. And I would simply say that acknowledgement by him, of course, doesn't change, and he made this clear himself, his position that what is in front of you is appropriate. So that response in answer to the question to you was not him resiling from his support for the proposal. I guess it was really simply reflecting a truism that the further back you push development into the site, the less you would see it. But nonetheless, Mr. Smith remains supportive of the proposal, and the McDonald's position is that as advanced, the loss of that setback is not of enough significance that consent should be declined. From para 58, then a very brief reference to provisions. I'm not going to go through those. The obvious things to say about it really are where there are references to character and amenity, that of course reflects where you land on what those are. It's not a hypothetical, as I said in opening, it's where you land in your analysis of that in reliance on the evidence that you've heard. Beyond that, this is maybe a rare scenario where a huge amount, I think, turns on ultimately where you sit on that character and amenity and effects paradigm for the fit with objectives and policies, because much of the objectives and policies are comfortably achieved. There are others where, despite wording around urban development and the like, you're already aware that, for example, in the consent order, the court has accepted that urban development can occur here. It's really about whether it's executed in a way that's acceptable. And so ultimately, I think where you land on those PDP provisions, not losing sight of the legal advice I gave you in my opening about how to grapple with conflicting provisions and directive wording, but much will turn on your ultimate views as to the environment and the effects of the proposal as advanced. That brings us then to minute 4 in questions about that earlier consent. Firstly, what conditions will need to be amended? So the variation aspect of what's in front of you relates to condition 1. And then from paragraph 64, in concert with some analysis by Barker and Associates, I've set out McDonald's position as to where change is needed or not. Now, I don't know that I need to go through those individually, but they are set out there in A through G with McDonald's position. And in short, the change needed from McDonald's perspective is obviously to condition 1. And other than that, perhaps condition 48. In paragraph 65, I then have a reference to how condition 1 might be amended. And then from paragraph 66, I engage with the implications if that resource consent is proceeded with in part. So McDonald's obviously have sought a new consent, which relates to the activity that they would undertake. The variation they propose simply relates to relocation of some consented planting. That planting isn't lost, but it is relocated. If that existing consent isn't fully implemented, McDonald's says that the planting it proposes is sufficient to mitigate its activity, irrespective of whether or not other planting associated with that existing consent is to occur. And in that context, both the McDonald's building and the planting associated with mitigating it will also have mitigation implications for views toward the service station location across that area of the broader site. From paragraph 70, I engage with the question of packaging waste, and I've provided you with a supplementary statement of Mr. Parkinson. I was in two minds as to whether that was necessary or not, because your minute direction in some respects was directed particularly towards sort of what people in Wānaka were, or at least some people in Wānaka are interested in doing and are attempting to achieve. But I felt it provided some context for McDonald's response on these matters, and it was an issue that was raised by a number of people during the hearing, that you have in front of you an understanding of the broader steps McDonald's are taking both internationally and in a New Zealand context. And it wasn't something that I felt comfortable simply repeating in a legal submission, because getting into a lot of evidence from the bar if I were to do that. So Mr. Parkinson's statement, you will have seen, is very much confined just to that issue, and it gives you some background to steps that are being taken. And I guess just to speak to that briefly, and he is available here today if you did need to speak with him, the point really, the takeaways from that really are, it's rather a bad pun, isn't it, takeaways, but the point really that is being made is that there is a focus on it by McDonald's, and that partly reflects, of course, societal pressure around the globe. And if you're being uncharitable, you could say as well that, frankly, saving on packaging and becoming more efficient with packaging has a financial implication as well. But McDonald's is cognizant of that issue. Various steps have been taken around the world, and there's some reference there to reuse and so on that Mr. Parkinson refers to. Interestingly, some of the reuse attempts have been found in a real-world scenario not to work as well as hoped, and that reflects things like people, frankly, sort of nicking stuff and not returning it, and then you have all the cost and energy. If you're talking about an end-to-end analysis, you have all the energy and implications of making reusable product, which then doesn't end up with the necessary life to pay back the implication of making it from an emissions perspective. And so there's a whole lot of complexity to the issue, is perhaps one of the takeaways that you can settle on. But the other is that McDonald's are doing those things, and they are making continual steps, as Mr. Parkinson's referred to change things, often at a granular level, but with an entity the size of McDonald's that can have quite a big impact. And so, you know, plastic straws are gone, and there's a commitment now and an achievement of 100% of the product being fibre-based and all these sorts of things. So there are continual steps that are occurring. That takes me perhaps to the legislation and the district plan. So there's some discussion there from paragraph 73 of the Waste Minimisation Act. So there's a focus in there around actions by council, but what could be said, paragraph 76 of this reply, is firstly, the plan applies across the district. It's not limited to Wānaka. And the risk of stating the obvious, there are 2 McDonald's restaurants in this jurisdiction already. There is a whole plethora of other operators, and including convenience food, fast food, people offering takeout offerings all across the district. And in that sense, Wānaka is no different to Queenstown in that respect. From a zoning perspective, you'll recall that drive-through restaurants are a permitted activity in the Three Parks commercial zone, and you will have seen from the email from Mr. Dippy, that's something unsurprisingly that they're exploring, and presumably not just with McDonald's. And a McDonald's restaurant could establish in the township proper, if you like, without a drive-through as a permitted activity as well. So the waste that's generated by an activity such as McDonald's is something which is anticipated by the plan. And there's some real world observations, and that I should interpolate. Of course, that doesn't mean that efforts shouldn't be made to manage that situation and mitigate that situation in an appropriate way. And McDonald's have signalled their agreement with that. But there are some real world observations in paragraph 81 I make as well. So firstly, that waste minimisation goal is something that's desirable for the whole community. But of course, we've got a range of commercial businesses in the town which sell product that's packaged. So this is not, despite so-called fast food being, a happy hunting ground for those who like to pile in on particular operations. There's a range of reasons why packaging is used with food. The obvious ones are food safety and all the rest of it. There are a range of other operations where and offerings where there are different packaging. And you frankly don't need to go any further than the 2 supermarkets in town, to pick one example, to find more packaging than you can shake a stick at. And much of it, maybe even the bulk of it, is not particularly capable of recycling or reuse. And so McDonald's shouldn't be singled out in that sense. It's a whole of community effort. What Mr. Parkinson's evidence says to you is that McDonald's are engaged with that effort and they are responding, and they have a commitment to continue to respond. It's also worth pointing out, as I do in paragraph 82, again, real world scenario. Firstly, it's pretty noticeable, I felt, and I think you felt that too, just evident from some of the comments and sheepish feelings about having a reusable cup on the desk during the hearing, that commitment by local cafes to reusable crockery and keep cups and all those things is notable, and McDonald's acknowledges that. But you have to say that those cafes which choose to be part of that exercise, and as I understand it, not all cafes in Wānaka are part of it, but those that do not represent a like-for-like comparison because they don't have a drive-through operation. So the McCafe that's proposed here will be no different than the McCafes elsewhere in New Zealand, and they do accept keep cups. So McDonald's doesn't reject that scenario. They are happy to accept keep cups, but it's for dine-in customers, and there are obvious reasons for that. Fundamentally, there's just no effective and efficient way to offer that same service for drive-through without creating a whole lot of difficulty for how the drive-through operates, which will generate other effects, and therefore you can't deal with it that way. And so for takeaway orders, whether walk-in or drive-through, disposable packaging is used, and that is the case for other food providers in Wānaka. You can point to Domino's if you want to pick a brand, or you can point to the food trucks at Brownston Street, which I visited those when I was there, and I know the commissioners did too, and the burgers or the burritos or whatever it may be come in some form of packaging. They have to, and that's unavoidable. I don't need to speak further about 24/7 operations. I've addressed that. And I then go on to touch on the fast track matter. So bill's passed, it's awaiting its royal assent. The Mount Iron Junction have that listed project. They're entitled, the date we have now is you can file from 7 February. I'm not familiar with whether they are hoping to file then, and there may well be a cast of thousands who are hoping to do that, and quite what that will look like, who could say, but that is the date at which such an application can be made. You referred to Ms. Mine hunting out where you can find that publicly available material. And I did include at 87 there. That link that's there should take you to, well, you can see all 140 odd projects if you're particularly enthusiastic, but one of them is the Mount Iron proposal. You can see the master plan there. You can also see the written application and various other material. Grant of consent can't be assumed. We've spoken to that before. It is a matter of record that the legislation gives primary weight in decision-making to the purpose of the Act, and that is fundamentally that development outcomes are prioritised. Again, you can quibble about whether that should be so, but that is the position we've ended up in. It's also the case from having a look at the Act that some of the most recent changes right at the end of the process before it was finally approved, I should say, involved some tweaks around what occurs if there's the potential for the proposal to be declined and there's a requirement on a panel to provide draft decisions to an applicant. The applicant expressly has the ability to make changes to the application to try and solve, to put it in a colloquial sense, any issues. And that seems to be intended to try and reduce how many ultimately get declined, albeit in that particular scenario, things would be scaled back. I'm not going to talk about that plan at length, but you've looked at it, obviously. And the most obvious thing that can be said about it, really, is that if it comes to pass, then the character and amenity of the site will be unequivocally urban. Might be the polite way of wording that it will be a complete and utter sea change for that site. And it would include removal of that landscape protection area. Quite how that unfolds is a matter for the developer. I don't propose to speak to that any further. You may or may not have questions, but I think in fairness, given it's been talked about and given you will remember I had seen this plan earlier in time, as had some of the McDonald's people, but it was provided expressly on the basis that it was not to be released, because the developer's position was that it would simply get released when the government decided it would do so. So now you have it, and it is a significant change. Other matters then to complete the exercise. The Willow Ridge email, I really referred to that simply because, as I understand it, Ms. Hill, either she was unaware of it or she didn't accept it was sent, and you've now seen a copy of it. And in it explains, of course, the unhappiness of McDonald's about the position which has unfolded, because it is expressed from that email that Willow Ridge is taking issue with McDonald's if it's located anywhere other than somewhere where they make money from it, in which case they're happy. Now, I can't make stick an anti-trade competitive complaint about that, but it is, frankly, rather distasteful behaviour, it has to be said. Turning to submitters then, you've heard from Mr. Herbert. And, you know, look, having just spoken about Willow Ridge and Mr. Herbert are sort of sailing under a common banner, at least nominally, but I don't understand necessarily that Mr. Herbert has the same enthusiasm necessarily for a McDonald's going in 3 parks as Willow Ridge does, but that's a matter as between them. Mr. Herbert's raised a range of issues around character, amenity, Mount Iron, which I've already engaged with. He referenced the petition, and I simply say in that regard, of course, that it's trite law that the RMA is not a numbers game. It's not a numbers game by reference to official submissions, and it certainly isn't by reference to an informal petition. I've mentioned already that aspects of my earlier submission are misquoted by him. And then transitioning on to both matters he raises and then things raised by the bulk of submitters. We've got character, landscape, amenity, and waste and packaging, and those are all things that I've spoken to thematically. In para 96, I refer to a submitter concerned about light pollution, and but frankly, there wasn't much evidence about what implications would be for insects or not. But in any event, that's responded to by adjustments to opening hours. Assertions that McDonald's doesn't care about the environment, doesn't care about community, values only financial return. There are submissions in front of you, getting colourful and talking about rapacious greed and all the rest of it. Look, McDonald's is a corporation that seeks to be profitable, and that's obvious, and that's part of its reason for existence. But you also have clear evidence in front of you about the range of commitments by McDonald's to charity, and those include sporting endeavour, and they include, as you know, of real significance in New Zealand, that commitment to the Ronald McDonald houses, which help families where they have people suffering terrible health issues. And they have a commitment, as the McDonald's evidence establishes, to continually manage and improve environmental impact. And there are certain outcomes from a business as large and successful as this which can appear outsized because of the success of the brand and the desire of people to go to McDonald's. But there is a clear commitment that McDonald's does care about its impact on the world, and it looks to improve it. Submissions about rockfall and engineering matters are resolved. I don't think I need to speak to those. There's that underlying flavour from some that they'd rather there was no quick service restaurants establishing in Wānaka, and the position fundamentally is that the plan provides for it, and whether it will occur, presumably is one driven by particular brand's interest in this location, and whether they perceive that establishing is something which is financially viable and valuable to them. And as a result, I simply say that personal aversion to quick service restaurants generally, or McDonald's particularly, is not a reasoned basis for this application for consent to be declined. The submission, Ms. Pounsford, that's the one that went completely off-road, as it were, engaging with conspiracy theories and Satan and all the rest of it. And I just would limit myself to saying that, there's no merit in getting into ludicrous conspiracy theories or unfounded and factually incorrect assertions. There were matters mentioned there, like some suggestion that there was some case with Jamie Oliver. That is factually untrue. And so I simply say to you that, unfortunately for that submitter, almost everything that was advanced is incorrect and should be ignored by you. And to the extent anything was raised that does tie to legitimate effects, you must consider those are matters engaged with by evidence on behalf of the applicant. Mr. Gilkinson referenced a publication by the Helen Clark Foundation, so I've read that report. And fundamentally, what I would say about it is, one, it really drives into issues and whether they need to be engaged with by central government. There is, in one small area of the report, some reference to whether that might include how planning laws are constructed, but it's not engaged at this point in time. And its primary focus was on advertising, whether you should have a sugar tax and issues like that. And it does also reference, in the context of where one has fast food restaurants, if we want to call them that, this concept of healthy food deserts, junk food swamps, all very colourful, but that is really about access to choice. And you have significant evidence in front of you that there is no shortage of healthy food choice in Wānaka, and that's in fact something that Wānaka is proud of, and that will not be lost by McDonald's being approved in this location. And related also to that is, of course, the fact that the McDonald's menu includes a range of choices, and it is also a matter of personal choice as to what one orders or not from McDonald's. In paragraph 102 then, to wrap up those submitters, there is a contrast a helpful one, I think, with those submissions from Dr. Power and Mr. Cossins, neither of whom have any relationship with McDonald's, but they express what I regard as a more balanced position where they offer support for the proposal in the context of acknowledging that people have personal choice, that there are a range of offerings in Wānaka already, which if you eat too much of them are unhealthy, and that there are some real world considerations around potential impact on Mount Iron and so on, which demonstrate that this proposal can acceptably and appropriately be consented in a manner that won't change the town's image or the image of Mount Iron. And that then leads to a conclusion, which I don't need to repeat. I would just note in paragraph 103, I've had an acronym sneak in from Auckland, so there's an AUP reference. It should be PDP, my apologies. So spoken too much about the AUP, clearly. Can't get away from it. But my submission then is in line with that in my opening, that you've heard a lot. And I say, for reasons expressed in the reply and all that evidence, that I maintain the view, subject, of course, to amendments now offered, that this proposal is deserving of consent.
Thank you for that. I'm just going to make just 3 observations or 3 comments that sort of address, they weren't really questions from you, but I can certainly confirm that I agree, or we agree, with your decision that you didn't need to call Mr. Smith to talk about the lighting issue. I also think the call with regard to getting that statement of evidence from Dan Parkinson was a really good one. I don't certainly have any questions of him, but it was really helpful. Look, if for nothing else, it's to put some balance back into the conversation, because, as you know, the submitters, many of them spoke from their own particular perspective. So it's very good to have formally in writing a specific response to that, which doesn't just come from the lawyer, it comes from a McDonald's person. And I'm just going to think, and the last thing I was just going to confirm is, it took me a while because I always find the MFE website a bit clunky, to be honest. But yes, I did note that those plans of those 140 odd proposals are now on the website, and including the Mount Iron one. So thank you for that. And as you say, who knows where to from here. I agree with your observations with regard to the legislation. It's essentially, it's essentially done and dusted. It's just simply waiting for the tick off from the Governor General, which is, more often than not, it's more often and hardly ever not, will happen. So I have got a couple of questions for you, but before I ask them, I'm just going to, I don't think Robert has any questions, Lisa, do you? Unless he's changed his position in the last wee while. But do either of you have anything?
No, I don't have any questions. I just wanted to make a comment about the changed hours. Thanks for giving that consideration, because I am also conscious that while we had a submitter who raised them, we didn't get any comment from Fens or St John's to back up his views. So so I appreciate you going back and giving that consideration and actually making that change, which of course impacts on the nightlight and amenity aspect as well. So thanks for giving that consideration and presenting that to us.
Thanks, Lisa. Robert, is anything changed for you?
No, I'll just reiterate those comments, and the submissions are quite clear. I don't have any further questions.
Thanks both. Just in terms of those changes that have been made, and I think you made the comment, Jeremy, with regard to whether we would seek any further comment from the council. I'm not minded to, but what I need to do sort of offline from this open conversation is actually have a conversation with both Lisa and Robert about that, including sort of timing issues. I'll come back to that in a minute. What I just wanted to ask you, and this isn't necessarily because I think this is really more when I'm thinking about, the way in which I would structure a decision or reflect on the matters that you've raised and that others have raised. I just have these two they are kind of questions, and I would welcome your feedback or comment on them. I agree with your comment with regard to the bindingness or otherwise of the Environment Court consent order process, but as well you and I know, and probably lots of other people on the call know, Environment Court decisions aren't even contested ones aren't binding, legally binding. They are often treated that way, weirdly, by some of our colleagues and the council community, but legally they are not. But what I was wondering, actually, this leads on to my second point, I think. So I agree, we do have to reflect on the legal test with regard to existing environment and what it is and what it isn't, and etc. And in that respect, and I know this happens quite a lot around the country, and Queenstown, it probably happens even more frequently, where a person will come along and they'll apply for consent. It'll be a whole bunch of things that are applied for consent. And then, time moves on and law changes, or maybe the economics change or whatever. And then, whatever they applied for then gets whittled away. So it either gets whittled away to such a point that it no longer exists as its original consent process, or, it gets little bits of it get taken out and bits of it get taken in. I'm not aware, there might be, I'm not aware of any court decision that has looked at, how far is too far. When you're talking about something that was consented, if you start to pare back too much of it, do you get to a point where you need to conclude that actually this consent is no longer realistically the legal, the test, ever going to be given effect to? What's really going to happen is this other thing over here. Now, we're not there yet with this one, but if McDonald's had come along, well, you might not have had to have come along, but if say, what am I trying to say? If say the Mount Iron Junction had not withdrawn the existing consent, but had either applied for a new one, or were in the process of just about applying for a new one that kind of had the bit of the look and feel of got rid of the worker accommodation, got rid of the visitor accommodation, how I'm just trying to get my head around how much of that existing consent is in fact even relevant to our consideration of the existing environment.
And my answer to that is the information that we have in front of us is an intention to progress the service station.
Yeah.
It's one of the things this is, this would be a lot cleaner if the fast track wasn't floating around. One of the interesting things about that fast track application, in addition to the plans, which I attached so you could see them, but if you had a look at the link, you can find the I guess the written application as well. The terminology starts getting slightly confusing about, it's an application to be listed as opposed to an application for consent, obviously, but the application to be part of the process, to be added to the schedule, to be a listed project is available as part of what's been disclosed.
Yeah, I know.
If you look at that, one of the interesting things about it is it's somewhat loosely worded about exactly what is intended to come within the ambit of the application. So the summary of it that was published by government earlier in time simply referred to 263 houses or whatever the number was.
Yeah, it did. It doesn't.
However, if you look at the project summary and the project details, there is discussion about a childcare centre and a retail building, and there's some suggestion potentially that the application might be is able scope-wise to go further than just the housing. Now, I guess the reason for making that point is that the plans, though, do record on them. Who could say how this ends up ultimately being dealt with? But the plans do record on them that the petrol station is previously consented.
Mm.
And my understanding of that then is a clear intention which aligns with the person who, if you like, has committed to purchase the site, the development opportunity, to deliver that part of the proposal.
Yeah.
I can't really take it in terms of what will occur much further than that. I understand the point that you're making. I think it's true that if you just changed, but I don't know that it takes us away from the core proposition. It's still about whether you're likely to give effect to it.
Yeah.
So I suppose, I guess what you're driving at is if someone reduced what they were likely to give effect to down and down and down, you would get to a point where the implication of that rump, whatever it might be, would not be particularly meaningful for your analysis of the environment. I don't think you could say that about a service station here, because although in terms of coverage of the site, it's relatively small, it is obviously an urban use that has some implications for how one might perceive the site. So it is certainly a significant subset of the broader, or it is a subset of the broader thing that was consented, but it is of enough significance that I think you wouldn't ignore it.
Yep. No, that's helpful. I'm not suggesting that, as you said in your submissions to us, I mean, you said in some ways it would be sort of more helpful if we didn't have that added layer of complexity to consider. We do have that added layer, and we just have to turn our minds to it and form a view on it in terms of what it means for our assessment, in particular, our legal assessment.
That's right. I mean, the point there, of course, is this isn't some Machiavellian strategy dreamed up by me as McDonald's lawyer. I mean, this is this is just, but I don't know whether members of the public have a degree of concern about that, but this is simply a scenario where McDonald's is progressing its application and the developer has control over the balance of the site, and they are doing their own thing, and they are making their own choices about how they progress.
Yeah, I mean, I think you're right, and we're both aware, and others will be aware of, that argument that it becomes a death by 1,000 cuts argument, and I know that has played out in Queenstown. So I suspect there are people who are concerned about that kind of thing. I'm not suggesting that that's the case here at all. Now, Lisa, in Robert, has anything arisen? I presume you don't have any questions for Jeremy, and there were no questions for Dan. What that leads me to talk to everyone about is the timing and the process from here. Today is the 19th of December. Tomorrow is the 20th. So there you go. I've got my maths right. And the relevance of that is that from tomorrow, or after tomorrow, we go into this weird space that's called, working days are deemed not to be working days, even if some of us are still working. They don't resume again until the 10th of January. But what I haven't spoken with either of my fellow commissioners about this, but what I'm hoping to be able to do before Christmas, even though it won't be a working day, is the next part of the process for us is confirmation that we can now close the hearing. We've got everything we need. We don't need anything else. So I just need to have a little bit of time to just confer with my colleagues and confirm that, which will be done in a minute. As soon as we close the hearing, the 15 working day period for issuing a decision starts to run. So even if we close the hearing, and it will be during this non-working day period, it takes us toward, and so we start again on the 10th of January, we're looking at issuing a decision by the end of January. Unless we were needing to extend that time, which we have the power to do. So again, I need to talk to my colleagues and just find out what their other commitments are. So I'm just letting you know that, you, Jeremy, obviously know all these things. So I'm just letting the broader group know that is the plan. So my hope is, and I'm committed to doing this. A decision, minute will issue before Christmas. I might even be able to do one. What are we today? Thursday. I might even be able to do one by tomorrow, or at the latest Monday. Just confirming the process and the timing. And then once you've got that, you've got some clarity around the next steps. Is that all good from everyone's point of view? I don't see any horrors of hands up from my fellow commissioners, but what I'll do with them is I'll set up a quick discussion with them after, not immediately after this, but after today, and then they'll be able to confirm their position as well. All right, so thank you everyone, and thank you to the McDonald's team for all turning up, and albeit remotely, and everyone else who's on the line, and everyone else who's watching, who's live streaming. This is live stream, so they're watching that. I'm assuming that, I don't know the process with Queenstown Lakes, but I'm assuming that it is in fact recorded, just like the hearing was in fact recorded, so it will be available to those who weren't able to tune in today. Is that correct, Lindley or Trish?
Yes, yep.
Yeah, that's great.
Find the live stream link only.
No, of course. Yeah, no, thank you. So I will, as I say, we're still officially in an adjournment space, but I will confirm us moving from that space before we all toodle off completely and close off all our computers over the short, the Christmas break. So look out for that. It will come out within the next couple of working days. So either, if not tomorrow, Monday. So thank you. And thank you for everything in writing, Jeremy. That's really much appreciated. I know, and again, I know it's many lawyers' preference to do oral closings, but it's really important from a commissioner's point of view to also get the material in writing and all of the amendments and things. And I do I'm really pleased that McDonald's has gone away and reflected very carefully on the issues that are of concern and have made the changes that they have proposed. It is very helpful for us to be able to have that additional material to reflect on in our process of consideration. So
Well,
thank you.
And thank you for the opportunity to present oral submissions. Of course, happy to and always do provide things in writing, but
I know you do. Yeah.
love an opportunity to also present directly and be able to have some back and forth. So thank you for that.
Well, it's hard enough to read a room when you're not physically in the same room, but but at least we have had that opportunity to be physically in the same room, so we've got a bit of a sense of where everyone's coming from. So, look, thank you, everyone. And to Lisa and Rob, I'll be in touch. I'll just make a time to suit you to have a chat about next steps. And to Lindley and Trish, I will be confirming next steps with you before you before you both leave for your break, so that we can at least have a process going forward and we know what dates we're working to. So I will close is the wrong word. I will continue to adjourn the hearing and we'll be closing via a minute in due course. Okay.
Thank you.
Thank you.
Thanks, everyone.
Thanks.
Thank
See
you.
you later.
Thanks, Queenstown Lakes team. Much appreciated. It ended up working seamlessly. Okay, bye.